Hello, everyone, and welcome to Uncivil Law. For today's case, we are dealing with Facebook, who did not respond to a court order and was being held in contempt. A person was seeking information that might have helped to exonerate them in a criminal case, and Facebook decided just to not give the information to the court, even though it was ordered to. So Facebook is being held in contempt. And this Court of Appeals case is dealing whether or not Facebook can be ordered to give this information and whether or not they should be kept secret, that they were. So let's get started with reading this. Mr. Pepe, who, we're just going to use the frog meme at this point because we can, who we will just alternate between calling Mr. Pepe and Mr. Frog because it's entertaining. So Mr. Frog subpoenaed evidence from Facebook supporting his defense to a then pending criminal charge arising out of shooting of Marquette Brown on December the 8th, 2018. Mr. Pepe the Frog claimed that he shot in self-defense after Mr. Brown and his associates who had been threatening him surrounded him on the A6 bus and pursued him when he tried to get off and walk away. Shortly before the encounter, Brown allegedly sent Pepe a disappearing Instagram story in which Brown menacingly bragged that he'd been carrying a weapon during one of their previous confrontations and warned Pepe not to ride the A6 bus. The A6 bus is where all the best confrontations happen. Mr. Pepe had not preserved and no longer possessed the story because it was a disappearing story, so he doesn't have it. It was not included in the voluminous records Facebook had produced to the government from Mr. Pepe's Instagram account in response to a search warrant, which the records turned over to Mr. Pepe in a pretrial discovery. The frog over here has received a threatening message from some other people. An Instagram story says, don't ride the bus. If you do, I'm going to come after you. And so he is claiming self-defense because of this threat. And he'd like access to that information because that would go to his state of mind, that he would be able to perceive a threat. So Facebook has turned over some voluminous information, but has not turned over this thing. Maybe because they don't have it, but whatever, but they haven't turned it over. So we're still trying to get to this. In an effort to obtain this effervescent, which is a very fancy word for saying disappearing, but I do like it, effervescent Instagram story and other potentially helpful evidence relating to these threats, Mr. Frog asked the Superior Court to authorize an ex parte subpoena to Facebook under the criminal law. The subpoena sought communications from Brown's Instagram account to Pepe's account and non-content information pertaining to Brown's account, such as message headers identifying other accounts with which Brown has to communicate around the time of shooting. The trial court approved ex parte subpoena and found the exceptional circumstances existed to dispense with requiring notice to Brown. So, yeah, the court, he's like, I want some information from Brown's account, from Facebook. Now, whether or not Brown should be notified is part of this issue. So Facebook wants to notify Brown as it's gathering this information. The court says, no, don't notify Brown. So the court orders initially give the information and don't notify the person who you're getting the information from, that you're getting information from their account. But Facebook would like to notify them, and the court says no. All right, so let's press on. Facebook also requested the court's permission to disclose the existence of the ex parte subpoena to the government or Mr. Brown so it could explore where the requested information could be procured without a subpoena. For example, if the government were to obtain a warrant for the information and thereafter produce it to Mr. Pepe. Mr. Pepe opposed the request, and the trial court ultimately rejected it and ordered Facebook not to disclose the subpoena to any person or entity other than its lawyers until it had complied with the subpoena. So Facebook said, well, maybe there's other ways for us to go about doing this other than the way you've proposed, but the court said no. The court concluded that this restraint on disclosure was justified by the law to prevent loss or destruction of information and to protect Mr. Pepe from premature disclosure of its defense, investigation, and strategy, and it did not violate the First Amendment. So, first, Facebook wants to alert different people. It's like, no, and we don't want to, make it available because it might be prejudicial defense and all kinds of reasons. So, initially, it's like Facebook, you have to comply and you have to not tell anybody. But that might be a prior restraint, so that might be a problem. Facebook did not comply with the subpoena by its deadline imposed on the court. The court accordingly held it in civil contempt for failure to comply. So yes, Facebook, you do actually have to obey court orders. On January the 16th, 2020, judgment in this appeal upheld the subpoena and affirmed the adjudication of contempt. We agree with trial court, Mr. Pepe, and the United States that the act does not require nor authorize Facebook's refusal to comply. However, we have vacated the non-disclosure order, so Facebook can talk about it, but they are still in contempt for failure to comply in the first place. Okay, so you might want to know a little bit about why Facebook was refusing to comply, on what basis there is. So there is a federal law, the Storage Communications Act, which provides that certain information is to be held in private. And Facebook read this law in such a way that says that they didn't have to comply if they didn't want to. They said, first of all, it doesn't allow us to, and second of all, it gives us discretion. So let's read this and figure out whether or not they're right. As a provider of electronic communication services, Facebook must comply with provisions of the law governing disclosure of communications and records. The provision of law that's applicable to this case, 18 U.S.C. 2702, contains a prohibition on disclosure and exemptions to that prohibition. The law provides that, except as provided in other parts of law, the service provider shall not knowingly divulge to any person or entity the contents of electronically stored communication, to any governmental entity, records, or other information pertaining to a subscriber or customer. If one of the exceptions apply, the provider may divulge the information or information at issue. Mr. Pepe contends the Storage Communications Act is no obstacle to the enforcement of his subpoena, because the exceptions in the law specifically allow a provider like Facebook to divulge the contents of a covered communication to, or with the consent of, an addressee or intended recipient of this communication, and customer records and information other than covered communication to any person other than a governmental entity. In opposing the request, Facebook makes two arguments. First, it argues Mr. Pepe is not an addressee or intended recipient of the Instagram communication that has by design automatically expired and disappeared. That argument is stupid. He's not an addressee because the communication has expired and disappeared. That makes literally none of the sense. It was directed to him at some point and some time. Who else would be the addressee? You're saying there's no addressee because there's no communication? There was an addressee. That argument is dumb. Second of all, Facebook argues even the subsections do apply, it cannot be compelled to do so because the statute preempts such compulsory discovery and commits the disclosure discretion in cases like this to discretion to its provider. Okay, that one's a little bit more promising because the language does say may. Now, we're going to have to get into what the precedent does say. But the first argument, he's not an addressee, that's just dumb. So it doesn't apply to the addressee because otherwise it would be stupid. Of course, a provider has to provide to the addressee because that's how like email works. You know, obviously they have to communicate it. So the Stored Communication Act doesn't apply to stored email when those emails are being directed to somebody because like how else would email work? Or Instagrams or anything else. So that argument's dumb. Second argument's a little bit more promising though. It says that the Stored Communication Act doesn't apply, the provider may, not shall. So the Facebook says, aha, this language says may. That makes it discretionary, so we don't have to. Okay, argument number 2 is a little bit more promising. Let's read on. Facebook argues that the frog cannot be considered an addressee or intended recipient of Instagram messages that have been expired and disappeared from his view after 24 hours. That argument is stupid. It doesn't make any sense. According to Facebook, a sender's use of such an ephemeral format implies the sender meant to limit the receiver's continued access to the messages and makes the receiver only a former addressee or intended recipient of the message once it's disappeared. What? Taken to its logical conclusion, Facebook's position is the receiver must have current access to a communication when seeking its disclosure in order to be deemed an addressee or intended recipient of it within the meaning of the law. How did Facebook dream this one up? This doesn't make any sense. In the ordinary sense of the term, being an addressee or intended recipient of a communication is not linked in any way to how long the receiver continues or intends to possess it. Right. Like, you're still an addressee even if it happened in the past. It was addressed to you. In general, an addressee is simply to one whom something is addressed. An address is simply a direction to go. We would not say, for example, that someone ceased to be the addressee of a letter that was deposited in the mail if the letter was lost or thrown away. Right. The letter is addressed to you. Whether or not it ever gets to you or whether or not you still have it is kind of neither here nor there. It was addressed to you. You're the addressee. Similarly, an intended recipient is simply one that receives, takes possession of, and has the sender in mind. The status of an intended recipient does not depend on whether the recipient keeps the communication or whether the sender intends the communication to be preserved. Please destroy this letter after reading does not make it not a letter that was addressed to you in the first place. That doesn't make sense. A person need not to record a phone call in order to be determined its recipient. Yeah. Phone calls are also pretty ephemeral. And so the Supreme Court's like, okay, phone calls are ephemeral. You're not the recipient because no one made a recording of it. How's that work? Conversations between two people that just happened in the public. Are you the intended recipient or addressee of that conversation? We literally call it addressing somebody, right? If we're just having a conversation, the two of us, I'm addressing you because it's intended to go to you. So no one is recording it, but you're not the addressee anymore because it's ephemeral. How does that work? It doesn't. This argument is lame. Facebook's lawyers are lame. This argument's dumb. We hold under the statutes, and for that matter, using English, that Mr. Pepe is an addressee or intended recipient of any communication sent to, intended to be sent, contemplated sending, all that good stuff. And those exceptions therefore permit the disclosure in response to subpoena, because of course they do. He's the intended recipient. What are you talking about? This literally makes no sense. This argument is stupid. Okay, so having disposed of Facebook's stupid argument and proving that even really, really paid lawyers can sometimes make really stupid arguments, we have a much more promising argument that we have to deal with. The statute seems to say that the provider may do this, not shall do this. And so Facebook argues this language is discretionary, which it appears to be on its initial face. So let's try a less stupid argument. Let's try the argument that says, an exemption applies, but it's within my discretion because it says I may do this, not that I shall do this. Let's give that a go. Facebook argues that the section states that a provider may divulge information under certain circumstances, and the permissive may, rather than the imperative shall, indicates the decision to divulge is discretionary. This is more promising. However, the court says the assertion is too sweeping. As the California Supreme Court has recently explained, the subdivisions in the statute where may appears are framed not as a grant of discretionary power, but as a special exception to a general prohibition. In such a context, all may means is that the actor is excused from duty, liability, or disability otherwise imposed by prohibition. So I like this analysis very much, and it makes a lot of sense. So basically, the way this is being phrased is it's may as an exception to a shall not. So the statute starts off with, you shall not do this stuff, right? This is not permitted. And then it says, here's some exceptions. So here's some exceptions. Now, those exceptions could be read a whole bunch of ways, but it's read as it's just excusing you. So when it says may, it's simply taking away the mandate. So now you're kind of left in a neutral place. So this may language is not really discretionary language. It's language that's simply taking away the disability from the earlier shall not. So I like this construction. It makes a lot of sense textually. So may is not read as you have the choice. It's simply reading as removing the disability. So you're now in a more neutral place. I like that. Indeed, underscoring this point, some of the accepted circumstances in which the exceptions say provider may diverge are in fact circumstances where provider must. And while the term may suggests discretion, it does not necessarily suggest unlimited discretion. This is another good point. So just because you have discretion doesn't mean that it is unlimited in nature. And so a thing that gives you power may not be unlimited power. So the statute says you may do this. It may not be that you have the ability to choose just completely willy-nilly. You may have to have some constraints. So, and those constraints may be provided by other operations of law, so we need to read that. Although the Secured Communications Act preempts other disclosure laws to the extent they would require providers to violate the law, that is no reason to think the Secured Communications Act also preempts laws that require disclosures that the law expressly permits. When the law lifts a bar on disclosure of electronic communications in one statute and expressly permits providers to disclose information, the requisite indication of congressional intent to preclude compulsory process is absent. It does not appear in the statutory text, and we have not found it in the history. Accordingly, we hold the Secure Communications Act did not authorize Facebook's refusal to comply with the fraud's subpoena for information that the Secure Communications Act allowed Facebook to divulge. The trial court found that Mr. Pepe has a compelling interest in having his defense theory, strategy, and investigation remain confidential. Sealing would serve that interest, and in the absence of sealing, the infringers would be harmed, and there are no alternatives to that sealing. Accordingly, the court ordered Facebook not to disclose the existence of the subpoena to any other person or entity, with the exception of its own lawyers, until after Facebook had complied with the subpoena. So, having determined that he is entitled to this information, we must now determine whether or not the requirement that Facebook not tell anyone about it was constitutional. So, it can obviously tell its own lawyers, But can it tell anyone else? Can it tell the people whose information it is? And the court initially said, well, he's entitled to his own defense. We don't want to let people know what it is prematurely. We don't want that information leaked. So the court said, I'm going to prevent Facebook from talking about it with others. So is that constitutional? Let's find out. We start with the understanding that witnesses and other third parties in possession of evidence relating to civil or criminal proceedings generally have a robust First Amendment right. The First Amendment is a good thing. It continues to exist. Whether or not they're under subpoena to speak freely about their knowledge and their involvement in a proceeding whenever and with whomever they please. Freedom of speech is good. This right extends to sharing evidence that they possess with either side in litigation. Witnesses do not belong to one side or the other. That's right. They can talk to anyone, anytime. They are not your witness. They're everyone's witness. That's right. The judicial order in this case mandated that Facebook refrain from discussing the subpoena for its evidence with anyone except its own lawyers. Such a naked prohibition against disclosure of its involvement in this litigation is fairly characterized as a regulation of pure speech. That regulation is both content-based, because it prohibits the discussion of a particular topic, the subpoena, and a prior restraint on speech, as it forbids certain communications in advance of the time the communication occurs or before the subject has an opportunity to make them. Content-based restrictions are normally subject to review under strict scrutiny, and prior restraint comes with a heavy presumption against their validity. Yeah, prior restraint is one of those things that's basically a huge constitutional red flag, and courts, unfortunately, do this with some disturbing frequency. Not a lot in the grand scheme, but enough to make me cringe at least. So there are a lot of courts out there that are issuing a lot of gag orders on prior restraint. People who aren't even parties to things, a prior restraint. And it's like, there is a First Amendment right, and prior restraint is really, really bad. Like, really bad. So all these prior restraint things, man, it's like, are you sure? Because a lot of these things, but yeah, courts sometimes abuse that, and this is one of those times. It's like, you can't do that, man. It's too much. Section 2705 of the Secure Communication Act itself provides that governmental entities may apply to a court for a non-disclosure order similar to the one applied here in order to delay notification to customers or subscribers that have records or communications that are subject to a warrant. Courts have reviewed such orders under strict scrutiny. We see no reason why a lesser standard of scrutiny should apply where a defendant, under the role to withhold notification, seeks a further order preventing a recipient of the subpoena for disclosing it. Our own cases addressing First Amendment limitations on protective orders have required that any order be necessary to ensure a fair trial or prevent the abuse of the discovery process and be carefully drawn so as to limit speech as little as possible. And in the cases cited by Mr. Pepe as requiring a showing of substantial likelihood of prejudice, ask at a minimum whether the applicant for the non-disclosure order has presented sufficient facts to persuade a court that prejudice identified might well be realized, and whether the proposed restriction is essential to the protection of particular government interests involved. Mr. Pepe has not met either prong of this standard. These now articulated rationales support our order of January the 16th, 2020, affirming the Superior Court's order holding Facebook in contempt, so you're still in contempt, and order denying Facebook's motion to quash and vacating the non-disclosure order. So that is the end of our coverage of the case of Facebook versus James Pepe. In this case, we learned that Facebook is in contempt for failure to provide orders. And they had to provide some information from an Instagram story that goes to show a criminal defendant might have perceived a real risk as part of a self-defense claim. And Facebook doesn't want to give this information and also would like to tell people about it. So the court rules that Facebook has to give this information. If the act doesn't apply on its own terms because he's an addressee, what are you talking about? It was sent to him. Of course he's an addressee. That doesn't make any sense. And just because the thing has disappeared doesn't make him not an addressee. So yes, and this language which says may merely removes the disability. So Facebook has to comply with the act and give the information over. So Facebook will presumably now turn over the Instagram story, assuming they have it to give, and go from there. But at least for the moment, that's the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.